You're watching The Legal Breakdown. Glenn, we have some breaking news here as it relates to contempt charges for members of the Trump administration. Can you explain what just happened in court?
Yeah, Brian, the Trump administration in the Abrego Garcia case moves closer and closer to contempt of court every day, but we're not there yet. So here's what's happened. Because the judge has a sense that the Trump administration has not been complying with the order to facilitate the release of Abrego Garcia and treat his case as it should have been treated had he not been unlawfully and unconstitutionally deported, she ordered discovery. In other words, she told Abrego Garcia's legal team, you can get documents and depositions and your questions answered under oath by government officials, by Trump administration officials who are involved in this ugly, unconstitutional deportation, so we can see whether, one, they're complying with my orders and they're doing anything to facilitate his release, and two, whether they have already defied her court orders, Judge Sini's court orders, such that she should initiate formal contempt proceedings. So what she did was she ordered discovery. She said, I'm ordering the Trump administration to sit for depositions, that is, answering questions under oath. I am ordering them to produce the documents that Abrego Garcia's legal team requests of them, and she ordered other discovery. So now what's happened, we can glean from this sanctions motion, is that the Trump administration is essentially saying, yeah, we're not complying with those discovery orders. So here's what we know. We know that Abrego Garcia's lawyers just filed a motion requesting permission to seek sanctions against the Trump administration for failing to comply with discovery orders. Now, what we don't know is any more than that, because the motion, the substantive motion with the facts and the information is under seal. But here's what we do know. Judge Sini's granted the motion for Abrego Garcia's legal team to seek sanctions. The reason that tells us quite a bit is because, think about it, lawyers can't just file sanctions motions willy-nilly, because it would make the other side look bad if, in fact, the other side wasn't doing anything wrong, wasn't violating any court orders. So you need to seek permission. You need to make a showing that your opponent is violating court orders before you are permitted to file that sanctions motion, and the judge just gave them permission to file the sanctions motion. She ordered that it be filed on June 11th, and then the Trump administration will have to respond.
So because they're moving forward with contempt proceedings, given that the Trump administration seems unlikely to comply, does that mean they've given up on trying to get the administration to facilitate the release of Kilmar Abrego Garcia?
Absolutely not. They're not giving up. They're saying, Judge, you need to start bringing the hammer down for their failure to comply with the discovery. In other words, providing the evidence we need so we can figure out what, if anything, they're doing to facilitate his release and what the court should directly order them to do concretely. Because, Brian, one thing that we've railed against all along is, hey, why don't you go ahead and facilitate the release of somebody? What the hell does that mean? You need to be more definitive. You need to draw a line in the judicial sand and say, for example, I'm hereby ordering the Trump administration to secure the release of Abrego Garcia by, I'll pick an arbitrary date, June 15, and return him to the United States by June 17. That would be an order that is clear, concrete, definitive, and if the Trump administration violates it, now we are into formal contempt proceedings with sanctions that can include imprisoning Trump administration officials for defying court orders. But because this sort of, why don't you go ahead and facilitate something, is just not clearly enough defined, that's why we have been spinning our wheels. It's all going to come to a head eventually. Unfortunately, it has not come to a head yet.
Well, look, I sympathize with the legal team for Garcia because it's been how long since the Supreme Court ruled unanimously against the Trump administration and it got kicked back into Judge Sini's courtroom? What are we doing here? How has this not been adjudicated sooner than this? I mean, I feel like for weeks we have been sitting here. It started off where we were supposed to see daily updates at 5 o'clock every day, and it's been a month. this is completely fallen off the zeitgeist here, and it's not just bad enough unto itself in the fact that that this case in particular isn't being resolved, but it also just in a broad sense emboldens the Trump administration to know that they just don't have to comply with the courts, because eventually the courts aren't really going to show much teeth.
Yeah, and what I will say is the courts typically move at a glacial pace. Now, urgency is certainly of the moment with Abrego Garcia, who even the Trump administration admitted it wrongfully deported to El Salvador and, arranged to have him imprisoned in El Salvador on the U.S. taxpayers' dime. I mean, you can't make this kind of crap up. So yes, urgency is of the moment, but what I experienced in my 30 years as a federal prosecutor, Brian, even in urgent situations, getting the courts to move forward, at light speed was, it took a Herculean effort. So I'm not going to say that Judge Sines should not be moving more quickly, setting shorter deadlines. I'm not going to say that. I'm saying that it seems like she's trying to keep on top of this, as best she can and keep everything moving forward. That is very, small consolation, cold comfort for
Right.
Abrego Garcia and his family. But, this is where we are in the process. A sanctions motion has been filed. People might want to know, okay, what do sanctions look like?
That was literally going to be my next question, is just for posterity here. Can you explain what sanctions even mean in the context of this case?
Yeah, so ultimately sanctions are not contempt, right? We're on our way. We're on the road to contempt, and we're going to get there. But sanctions are kind of an interim step. So for example, if the Trump administration says, yeah, you know what? We're not sitting for depositions. We're not answering interrogatories, a fancy word for having to answer written questions under oath, and we're not producing documents like the judge ordered us to do. Well, then the judge can order the payment of expenses to Abrego Garcia's lawyers. She can order attorney's fees be paid to Abrego Garcia's lawyers. She can preclude the government, the Trump administration, from using any evidence that might be helpful to them in future hearings. And ultimately, a judge can order what's called the default judgment. If one party says, guess what? I'm not participating in discovery. I'm not complying with court orders. A judge can say, oh, guess what? Then you lose, case closed. Now, all of those things feel like they are of limited utility in the context of the Abrego Garcia case because, we're trying to have returned to the United States somebody who should never have been unconstitutionally deported in the first place. So attorney's fees and expenses and default judgment ending the case doesn't really accomplish the goal here. But mind you, this sanctions motion is kind of a run-of-the-mill motion under the federal rules of civil procedure, Rule 37, for anybody scoring at home. And usually it's when there is ongoing litigation, there's an active case between two litigants that is headed toward a trial. That's where sanctions can be really impactful. Here, less so, but the judge, I think, is trying to do whatever she can do to move the Trump administration forward, to comply with her orders. But, let's all, keep an eye out for the coming contempt proceedings because they're coming.
Now, to that exact point, the Trump administration knows that they want to defy all of these court rulings, and they know that the one recourse that the courts have here is to impose both sanctions and to engage in these contempt proceedings, which is why they inserted in this Republican budget bill a provision that would strip the courts of their ability to engage in these contempt proceedings. So can you explain that provision and what it would mean in terms of the courts actually being able to enforce their rulings moving forward?
Brian, I'm going to make a prediction at my own peril. That proposal, that part of the pending bill is dead. It will be killed either in the Senate or if it makes it, it is so blatantly unconstitutional as a violation of the separation of powers. You can't tell the court you're not allowed to enforce your own damn court orders because if you do that, you're bringing an end to the co-equal branch status that the judiciary enjoys. So ultimately, that will be struck down by courts. I don't happen to think it will remain in the final bill. I could certainly be wrong about that. But yeah, that is just absolute nonsense that they have that provision in the bill. Yeah, but Brian, in the horrific event that passed, it would mean the courts could continue to function, the courts could continue to issue court orders with a view towards sort of the orderly administration of cases, civil and criminal. But if litigants, including the federal government, decided to disobey, blow off the court orders, there would be no enforcement mechanism. Now, it also is tied to the litigant having to post a bond in the amount that might represent the damage done if the judge is wrong about issuing an injunction. I don't want to turn this into a civil or criminal procedure class, but basically it would be neutering the court and the court's ability to actually function effectively. It would be like, well, the court is really there for show, because if we defy their orders, there's not a damn thing they can do about it.
Right. More broadly, though, what does it say that this administration is looking for other ways, not to just comply with the court's rulings, not to respect the autonomy of a co-equal branch of government, but trying to figure out ways to strip other branches of government, other co-equal branches of government, of their authority to enforce their own power?
Dictators gonna dictate. That's what they do. Donald
Right.
Trump is grasping for all of the dictatorial power he can possibly get, and then hope that the courts will rule in his favor. Brian, I'm almost beginning to feel like in the Abrego Garcia case, they are goading the Judge Sines, into holding contempt proceedings and finding that the Trump administration and its officials are in contempt, because maybe they want to then bubble that up through the appellate court to the Supreme Court, and then they will take their cues from whether the Supreme Court says, yeah, this kind of contempt proceeding is not only appropriate, but it's lawful, constitutional, and necessary, or maybe they strike down the contempt proceeding. And what does that do? Well, that emboldens Donald Trump to be even more lawless, more the tyrant, more the autocrat that he has such an appetite to become. So that may be actually part of DOJ's dirty strategy here.
Well, look, we will, of course, stay on top of this issue, especially as it relates to the prospect of sanctions, or beyond that, contempt charges against this administration. So for those who are watching, if you'd like to follow along, please make sure to subscribe. The links to both of our channels are right here on the screen. It's the best way to support our work and independent media more broadly. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.